But if we want to be honest about it, it's my understanding that there was an $18.8 million verdict that was just handed down by a jury to a man in California against your corporation as it relates to talcum powder. That was just in July, I believe, of this year. And so this idea that the third-party financing or seeing something on TV somehow then validates the claim. They still have to go through court. They still have to have expert reports. They still have to have attorneys. They still have to make sure that they take depositions. They still have to go through the entire discovery process. And a lot of times, at least in my experience, when it comes to defense, you end up with so much paperwork that you may end up needing a doc review team to go through all of the paperwork that is thrown on a simple plaintiff that may not have a large law firm that is behind them. And so what we are doing is saying if you have money, then you can access justice in this country. But if you don't have money, oh well, because we want to make sure that we know where your money is coming from, and that's just not fair. And the one thing that justice is supposed to be, that unfortunately we still are trying to get to in this country, justice is supposed to be blind.
You ever watch something and just think, this right here is why we've got so much work to do? That's exactly how I felt watching this. There were moments where you could see who's really about the people and who's just putting on a show. Trust me, this hearing had it all. Facts, fire, and a lot of folks getting checked. Representative Jamie Raskin wasted no time addressing the elephant in the room, the corruption in the Supreme Court. He laid it out with the kind of honesty we need more of in Congress. Raskin called out how the highest court in the land seems to be serving special interests instead of justice.
Well, thank you, Mr. Chairman, and thanks to our witnesses for being here today, especially Professor Clark, who flew all the way from St. Louis on short notice. Mr. Chairman, I spent my recess traveling across America. I was in 10 states, including your beautiful Kentucky. And one thing I found is that all over America, people are in an uproar over the money that billionaires are spending to influence justices on the United States Supreme Court. Americans see that personal gifts to justices from right-wing billionaire sugar daddies like Harlan Crow and Federalist Society dark money expenditures are fundamentally perverting judicial ethics and undermining justice and the rule of law. Now, apparently responding to the national outcry over this ethics crisis on the court, our colleagues have called a hearing today about the influence that wealth exerts on the justice system, but they've gone off on a surprising and bizarre tangent. The problem, they say, is not the way the public is harmed when billionaires bankroll the private lives of ethically challenged Supreme Court justices. The real problem is that giant corporations are harmed when Americans injured by toxic torts or environmental crimes receive contributions from donors to help them bring personal injury or class action lawsuits. In other words, while Supreme Court justices are jetting all over the world on fancy private family vacations paid for by right-wing billionaires or collecting hefty cash gifts from those billionaires for their personal museums and family members' private school tuition payments, the GOP says the real problem in our legal system is that too many victims of corporate wrongdoing are finding access to the courts in the first place. Now, we say justice is blind because the Greek statue for justice wears a blindfold. In solving cases, justices are supposed to be blind to wealth and poverty, personal friendship, and political affiliation. A poor person who has never met a judge must be treated the same by the courts as Harlan Crow, the real estate tycoon chum of Justice and Mrs. Clarence Thomas, who had a case before the Supreme Court and who has given the Thomases lavish personal gifts like week-long luxury travel on his super yacht and private jets and generous money payments for family tuition over a period of 20 years ever since Thomas joined the court. A collector of not-so-fine art created by dictators who actually owns and displays two paintings done by Adolf Hitler, Mr. Crow donated $105,000 to the Yale Law School in 2018 for another painting he desires, writing a check to the, quote, Justice Thomas Portrait Fund. But Justice Thomas isn't unique. He's just emblematic of the collapse of legal ethics across the street. Justice Alito took a long fishing trip with a hedge fund magnate who's had business before the Supreme Court 10 times in the last 15 years. Neither justice recused himself in the relevant cases or made any relevant, timely disclosures. Justice is supposed to be blind to the blandishments of money and class power. It's only supposed to see the facts and the law, but in the Roberts Court, judicial vision is clouded everywhere by dollar signs and luxury power trips. The facts and the law are barely visible when it comes to the rights of workers trying to organize a union, or poor women seeking abortions, or consumers injured by adhesion contracts and corporate ripoffs. Justice is a rich man's game in this court of billionaires. The Bill of Rights has mostly been left in the dust. On the Roberts Court, justice is indeed blind, but only to ethics itself. It is deaf to the pleas of women and working people, and it is dumb in its refusal to see how it has destroyed its own legitimacy in the eyes of the public. It is certainly not mute, however, as Justices Alito and Thomas vociferously defend their jet-setting lifestyles in shockingly intemperate terms. If we're going to return to equal justice under law, as it's written over the entrance to the Supreme Court, if we're to make justice blind to the wealth and the identity of the parties in the courtroom, then our justices must be held to the highest ethical standards. And yet, amazingly, the justices are not even subject to the basic code of conduct for United States judges that all other federal judges are subject to. The 9 justices are, in fact, not bound by any ethical standards at all, much less the comprehensive ethics code that applies to all the other judges. Their decisions can affect or destroy the rights of all Americans, but the justices refuse to abide by any written ethical code. They decide on their own if their work is impaired by a real or apparent conflict of interest, a terrible system which cuts against the key principle of justice that Madison articulated in the Federalist Papers. No man is allowed to be a judge in his own cause, in his own case. The highest court in our land now has the lowest ethical standards. This is the crisis we should be discussing today. But our colleagues have instead called a hearing to assert that it's just too easy to haul corporations into court when they violate other Americans' rights. The third-party litigation funding under attack today is the only way that a lot of victims of corporate misconduct can even get into court. Do our colleagues really want to make it illegal now to receive contributions to vindicate your rights? I could understand if they were saying that all the present federal rules of civil procedure against frivolous, vexatious, and groundless litigation weren't working. I could understand if they were arguing that Rule 11 sanctions against baseless lawsuits needed to be expanded or fortified, but that's not what they're saying. They're not citing any kind of increase in frivolous or meritless litigation, nor are they arguing that current sanctions don't work. Those sanctions are working just fine. No, they're looking for ways to reduce the prosecution of merit-worthy and successful lawsuits against actual corporate wrongdoers. And by pulling the rug out from underneath actual tort victims, they hope to keep plaintiffs from even getting into court. The GOP wants to dramatically reduce accountability and liability for corporations that flood our country with opioids to make obscene profits, corporations that poison our communities with asbestos or lead and other dangerous carcinogens, and corporations that inflict black lung disease, mass oil spills, and other lethal injuries on American communities. Our colleagues seem confused. No one has a right to bribe judges or load them up with fancy gifts, but people do have every First Amendment due process and equal protection right to raise money to make their case in court. The courts are not just there for rich people who can write themselves a big check. This is the same reason people have a right to give and receive campaign contributions for public office, is not just for the independently wealthy. Victims bringing these lawsuits, especially those who are low income or unable to work because they're sick or injured, often cannot afford to bring the lawsuits at all without financial help from other citizens. If their lawsuits have no merit, they should be thrown out. But if they have merit, then we should all be grateful that they are working to make society safer by stopping the wrongdoers before they commit more wrongs against society.
Let's get into Representative Marjorie Taylor Greene and her usual antics. This time, she went on about how there are groups out there supposedly funded to vote her out. She tried to paint herself as some kind of target of a big conspiracy. But let's be real. When you spend so much of your time stirring the pot and dividing people, it's no surprise that folks want you out of office.
I agree that third-party litigation that is funded by groups that have interest in these issues is causing many frivolous lawsuits. I want to explain a situation that's happening in politics. Dark money-funded lawfare is waged against candidates, against groups to sway politics and also interfere in elections. On March 24th, 2022, a group called Free Speech for People, which is an ironic name, filed a lawsuit against me using the 14th Amendment to try to remove my name off the ballot in my district in Georgia. This group, Free Speech for People, has received funding from leftist groups like San Francisco Foundation, Kohlberg Foundation, Leonard and Sophie Davis Fund, Overbrook Foundation, Park Foundation, Schumann Media Center, and Cloud Mountain Foundation, and many more. These groups are groups that claim they care about defending democracy, but they funded a group called Free Speech for People that was interested in taking away the free speech of the voters in my district. These groups from San Francisco and New York, all they did was fund a group to interfere in an election in my district in Georgia. On April 22nd, I had to go to court where I took the witness stand defending myself under oath against a lie launched and funded by this dark money group and run by far-left political operatives like David Brock and Norm Eisen. But I won. And it cost me almost $1 million defending myself. And then 1 month later, I had my election day on May 24th, 2022. Well, I want to tell you I won again because the voters in my district voted for me with over 70%. But this is still happening, and it's happening again to interfere in the 2024 election. Last Wednesday, a lawsuit was filed by Citizens for Responsibility and Ethics in Washington, CREW, to have President Trump removed from Colorado's ballots over claims he violated Section 3 of the 14th Amendment on January 6th. This is the same thing Free Speech for People tried to do with me, and I beat them, and President Trump will beat them as well. CREW was founded in 2003 by Norm Eisen, the same activist that was probably involved funding mine, and Melanie Sloan, to be a progressive watchdog group. Democrat operative David Brock of Media Matters, also well known for the Brock Memo, was chairman of the board of directors from 2014 to 2017. Norm Eisen worked for the ADL in the 80s, investigating anti-Semitism and civil rights violation. He worked on his law school classmate Barack Obama's presidential campaign and then was named special counsel for ethics and government reform in the White House. In 2019, Eisen was appointed consultant to the House Judiciary Committee, where he worked on the first impeachment of President Trump. You can see where this goes, ladies and gentlemen. It's all about politics. Eisen implemented the David Brock blueprint for suing the president into paralysis and his allies into bankruptcy. He helped mainstream and amplify the Russia hoax. He drafted 10 articles of impeachment for the Democrats a full month before President Trump ever called the Ukrainian president in 2018. He personally served as special counsel litigating the Ukraine impeachment. He created a template for internet censorship of world leaders and a handbook for mass mobilizing racial justice protesters to overturn Democratic election results. There is perhaps no man alive with a more decorated resume for plots against President Trump than Norm Eisen. All of these actions were part of the David Brock memo, which outlined how to defeat President Trump through lawfare, funded lawfare. The next step is Eisen and Brock's plan is to take President Trump and his allies out before the presidential election of 2024. They are trying to use January 6th as the reason for filing lawsuits against President Trump in various states, arguing he violated the 14th Amendment and is supposedly guilty of some so-called insurrection that never was, and therefore would be ineligible to run for office. CREW, the organization Eisen founded and Brooke chaired, is one of the main groups devoting funds to this goal. We have to stop funded lawfare by political organizations that want to take away people's freedom of speech to vote for the candidate that they want to vote for. And we also have to stop these dark money funded groups from interfering in elections. I yield back, Mr. Chairman.
And then there was Representative Jasmine Crockett, who came in with the real talk we needed to hear. She didn't sugarcoat anything, calling the Supreme Court exactly what it is, corrupt. She made it clear that justice isn't blind anymore. Instead, it's looking at the size of your wallet. Crockett broke it down. If you've got money, the system is on your side, no matter what the facts say. Her words hit hard because they shine a light on what so many people feel, that the system is rigged for the wealthy while everyone else gets left behind.
I think my colleagues have made it clear that we have a corrupt Supreme Court, so I'm going to spare you on that part. I do want to make sure that people understand how confused I've been in this hearing. Number one, it sounds like my colleagues from across the aisle are somehow believing in climate change now, so I'm excited to hear this, because I thought it was a farce and a hoax, but we talking about renewables and we care, so that's really good that we got that going. Interestingly enough, I had the privilege, or maybe not so much, when I started my legal career, my first job was to actually defend a large pharmaceutical company. I hated practicing law. I decided I needed to do something else, and so most people only know me for doing civil rights or criminal defense or the things that really matter to individual people versus doing the bidding of large corporations. And so I want to walk through this just a little bit and lawyer out a little bit, because I'm going to tell you from the onset, one of my issues with this whole concept is, number one, we have a little thing called attorney-client privilege, and in my opinion, we are starting to get dangerously close to piercing that privilege, that relationship between the attorney and their client when you start saying, well, how are you funding this and things like that? Because let's say I'm using my own money, fine. Let's say I'm using a third party. Why is it that the opposition has the right to know what my strategy is, or why it is, or who's helping me to do what? That's number one. Number two, if we are complaining about frivolous lawsuits, we have a thing called sanctions. For the lawyers here, has anyone heard of sanctions? Please raise your hand. Okay, thank you. Have we heard of a thing called a 12b6 motion? This is for anyone that practices on the federal level, but it is a motion to dismiss that most defendants, unless you want to have a problem with your bar card, most defendants file a 12b6 motion to dismiss for failure to state a claim very early on if there is a problem with litigation. Is that true or not? Can I get a raised hand? Okay, all right, Ms. Clark agrees with me. So part of my issue is that we have certain mechanisms in place already, and the only thing that we've talked about, or seemingly one of the things that's been an overarching theme today, has been about the client advertisement, talking about the commercials. But the cost of actually prosecuting a case is more than a commercial. In fact, a commercial is not necessarily required from my experience. I've only been out of practice for a little less than a year now. But has anyone ever been involved in a lawsuit, say Ms. Wine, where maybe an expert report was required?
Congresswoman, in most of the cases,
Especially mass tort.
Expert reports are required.
Okay.
In addition, in all mass tort cases today, millions, if not hundreds of millions of dollars are spent on advertising.
I hear you, because you have made that clear, but the reality is that people use third-party financing for things other than just advertising. And let me be clear, it's not just going to affect Johnson & Johnson, who last time I checked is doing okay on their profits, but as I switch over and talk about my life as a civil rights lawyer, a lot of times you have a family who has someone who has potentially been killed by law enforcement. And a lot of times, we don't necessarily have the money to front for all the experts that are required just for you to have your day in court. And so this has been couched as something frivolous, but if we want to be honest about it, it's my understanding that there was an $18.8 million verdict that was just handed down by a jury to a man in California against your corporation as it relates to talcum powder. That was just in July, I believe, of this year. And so this idea that the third-party financing or seeing something on TV somehow then validates the claim. They still have to go through court. They still have to have expert reports. They still have to have attorneys. They still have to make sure that they take depositions. They still have to go through the entire discovery process. And a lot of times, at least in my experience, when it comes to defense, you end up with so much paperwork that you may end up needing a doc review team to go through all of the paperwork that is thrown on a simple plaintiff that may not have a large law firm that is behind them. And so what we are doing is saying if you have money, then you can access justice in this country. But if you don't have money, oh well, because we want to make sure that we know where your money is coming from, and that's just not fair. And the one thing that justice is supposed to be, that unfortunately we still are trying to get to in this country, justice is supposed to be blind. And unfortunately, I believe that this is the wrong venue. This is also the wrong body, because we do have bar associations. We do have courts and judges that have the ability to issue sanctions, that have the ability to dismiss cases. And if we have some issues with the qualifications of judges, which I do, we know who we need to talk to about that as well. With that, I will yield.
And then Representative Jared Moskowitz came in with some real clarity about judicial activism. He didn't just toss the term around like some political slogan. He explained exactly what it means and why it's such a problem. Moskowitz made it plain. Judicial activism happens when judges stop interpreting the law and start pushing their own political agendas.
Pleasure to be here at this lovely filler hearing. It's not gone, I don't think, exactly as my colleagues thought it would go. You know, sometimes when I sit here, I often think to myself, who's in the room when these things get planned out? And like let's decide who we're gonna call. I don't know, let me find some sympathetic people to bring to this hearing today. Let me find a giant bankrupt corporation. Let me find an oil guy to talk about the Gulf of Mexico 12 times and how our national parks are getting better because of the Gulf of Mexico. Not really during the BP oil spill, but we won't go into that. I mean, we talk about judicial activism. I mean, I often think to myself, like, what was it not judicial activism when we had a judge meet with U.S. senators and say privately that Roe v. Wade was precedent on precedent, and then go in front of the Senate under oath and say the same thing, and then in their very first time, right, take back a law that had been there for 50 years? That's not judicial activism. And by the way, it would be an anomaly, except it didn't happen once, it happened twice. 2 judges appointed by Donald Trump that went and met with senators and said Roe v. Wade was precedent on precedent, and then went in front of the Senate under oath and said the same thing, and then get on the court. And in their very first couple of years, what do? They get rid of a law that had been there for 50 years. And so listen, I'm more than happy to listen to the cries of judicial activism, but we can no longer sit here and just pick when we like it and when we don't because it fits the politics of our time or the narrative that we're interested in. We sit here and we hear about, transparency. We want judicial transparency. I mean, it's almost like when this hearing was decided, maybe it was so long ago now that it wasn't in the news. I mean, boy, judicial transparency is really timely. So yes, thank you for bringing that forward about transparency in the legal system. I'm not sure that the American people are wondering about third-party litigation funding, but they're definitely worried about transparency with the highest court in the land, where there is no remedy when you have ethical violations other than impeaching a judge in the Senate. And so, listen, we should do a whole hearing on judicial transparency, because I think it's timely. I think the American people want to hear about it. It's just fascinating to me as we continue to sit in these hearings in oversight. I mean, we've had 9 months of hearings on a very specific topic. Those have gone so well. We're now we're gonna rebrand those hearings and hit the video game reset button, start all over again, right? I mean, it's just interesting. We sit here, we hear our colleagues bring up certain things like, oh, the Biden family took money from a foreign entity, right? And it's just like, well, really? I mean, do they really not know that Jared Kushner took $2 billion from the Saudis? I mean, by the way, they go on Twitter and blame the Saudis for 9/11. But then Jared Kushner, who, by the way, was not a wealth expert before he worked in the White House, nor was he a Middle East expert before he worked there, gets $2 billion from the Saudis and they don't have any questions. And I just think that the American people recognize that they have no credibility. It's why the stuff they've been selling in this committee for 9 months has not translated, which is why they got to start it all over again. You don't have any credibility when you only want to look at one side of the coin, right? And so, listen, I appreciate the time, Madam Chairwoman, but I just feel like I'm not going to beat up on you guys anymore. I think that it's been quite obvious that the way this hearing has gone. And so I want to thank all the witnesses for coming today. It's probably not what you bargained for, what they told you this would be like, but I appreciate you all for coming, and that I yield back.
That's it for today, y'all. This hearing showed us a lot about where people stand and who they're really fighting for. Thanks for watching, and remember to stay woke. See you in the next one.